Tonight, we examine a deleted message, a brother's legal luck, and a complete rewriting of the rules inside the Department of Justice. We go behind the scenes of a system in crisis, from high-level political pressure to the constitutional rights of every American. For decades, the United States Department of Justice has operated on a foundational principle that is often taken for granted. This principle holds that the power of federal prosecution should be insulated from the personal and political whims of the person sitting in the Oval Office. It is the idea that the law is a neutral set of rules, and the people who enforce those rules should be career professionals who do not change with every election. But tonight we have to look at a series of events that suggest that foundation is being systematically dismantled. The most serious development we are tracking involves a fundamental shift in how the Department of Justice, or DOJ, handles its own internal ethics and personnel decisions. On January 27, 2025, a memorandum was issued by Acting Deputy Attorney General Emil Bove. This memo did something that veteran observers of the department call alarming, and a dramatic departure from the practices of both Democratic and Republican administrations. It took the authority to decide sensitive ethics issues, employee discipline, and whistleblower complaints away from a senior career official and handed that power to two political appointees. One of these appointees graduated from law school only 4 years ago in 2021. The other is a former criminal defense attorney who served on Donald Trump's own defense team. These two individuals, who have never worked for the Department of Justice before, now have final decision-making authority over things like bar referrals and adverse personnel actions. Perhaps most importantly, they now have the power to approve ethics recusals and waivers. This means they can decide whether top officials, including Attorney General Pam Bondi herself, can participate in cases where they might have a personal financial interest or a conflict of interest. This move effectively removed Associate Deputy Attorney General Bradley Weinsheimer, a long-serving career official, from his post overseeing these matters. Members of the Senate Judiciary Committee have noted that this change happened despite Attorney General Bondi's sworn testimony during her confirmation hearing. At that time, she pledged to consult with career ethics officials to avoid conflicts of interest related to her past work as a lobbyist for corporate giants and foreign regimes. By replacing those career officials with political aides who report directly to her, the roadblock to potentially unethical actions has been essentially cleared. The consequences of this shift are not just theoretical. We are already seeing a pattern of interventions and dismissals that involve the Attorney General's own family. Members of Congress have expressed serious concerns about repeated DOJ actions that favor clients represented by Mr. Bradley Bondi, who is Pam Bondi's brother. For example, in August 2025, the DOJ took the unusual step of intervening in litigation in Hawaii regarding a state surcharge on cruise fares. The DOJ filed its motion to intervene in the late hours of the night right before a scheduled hearing to dismiss the case. The plaintiff's attorney in that case happens to be Mr. Bradley Bondi. The pattern goes further. In early 2025, the DOJ declined to seek an indictment against Carolina Amnesty, a former Florida state representative who had been charged with theft of government property involving $122,000 in COVID-19 relief loans. Ms. Amnesty had retained Bradley Bondi as her lawyer just 1 month earlier. In another case, charges were dismissed against a property developer named Siddharth Chakravarty, who had also hired Bradley Bondi. This dismissal occurred even though career prosecutors and a Trump-appointed interim U.S. attorney reportedly believed that criminal penalties were warranted. Even when Bradley Bondi's clients are convicted, they seem to find a path to a favorable outcome. Trevor Milton, a Utah billionaire convicted of securities and wire fraud in 2022, was represented by Mr. Bondi. In March 2025, President Trump gave Mr. Milton a full and unconditional pardon, allowing him to avoid a 4-year prison sentence and court-ordered restitution to harmed shareholders. These actions have led members of Congress to ask whether DOJ's impartiality has been compromised and whether internal safeguards are being bypassed. While these structural changes and family connections were unfolding, a separate but equally significant event occurred on social media. On September 20th, 2025, Donald Trump posted a message on Truth Social that appeared to be a private direct message or DM intended for Attorney General Pam Bondi. In the post, which was later deleted and then reposted, Trump rebuked Bondi for a lack of action against his political adversaries. He wrote, "Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action. What about Comey, Adam Shifty Schiff, Letitia? They're all guilty as hell." He complained that the delay was killing our reputation and credibility and concluded with the demand, "Justice must be served now." When later asked by reporters if he was upset with Bondi, he stated, "No, I just want people to act. We have to act fast." This misfire provided a rare window into how the president is directly pressuring the Justice Department to prosecute specific individuals like former FBI Director James Comey, Senator Adam Schiff, and New York Attorney General Letitia James. Legal experts, including former federal prosecutor Preet Bharara, say this accidental post could be a big problem for the DOJ. It provides a basis for these individuals to file motions to dismiss any future indictments on the grounds of vindictive prosecution, arguing that the charges were brought due to personal animus rather than legitimate legal reasons. In fact, we have already seen the first major collapse of one of these revenge cases. In November 2025, a federal judge dropped criminal indictments against James Comey and Letitia James. The reason was a procedural blunder that many legal observers say was entirely avoidable. The prosecutor who brought the charges, Lindsay Halligan, was found to have been not lawfully appointed to her position. Halligan, who previously worked in insurance law and represented Trump in the Mar-a-Lago classified documents case, was the person Trump had suggested Bondi elevate to the position of U.S. Attorney to reinvigorate investigations. The failure to follow standard appointment procedures led a federal judge to kill the cases against Comey and James. Trump's own former White House lawyer Ty Cobb called the situation shocking and suggested that Bondi and Halligan could be disbarred for what he described as either lying to the court or gross incompetence. Despite the judge's order, reports surfaced that the DOJ continued to sign criminal indictments with Halligan's name. This sense of urgency and the dismissal of procedural red tape is also visible in the ongoing controversy surrounding the Jeffrey Epstein files. Under the Epstein Transparency Act, the Department of Justice was legally required to produce all relevant records by December 19, 2025. However, on January 5, 2026, the DOJ submitted a status report to a federal judge in New York admitting that they had not complied with the law. The report, signed by top officials, including Todd Blanche and Pam Bondi, stated that while they had produced 125,000 pages, there were still more than 2 million documents potentially responsive to the act that were still being reviewed. They asked for an extension of time, citing "dog ate my homework" style excuses like the volume of materials and the need for redactions. Legal analysts argue that by signing this status report, Bondi and Blanche have essentially incriminated themselves in a violation of a federal statute. Furthermore, the DOJ has been accused of taking liberties with redactions that are not authorized by the Epstein Transparency Act. For instance, they have been redacting information based on deliberative process privilege and attorney-client privilege, even though the law only allows for the withholding of information that identifies victims, contains child abuse material, or jeopardizes an active investigation. This has led to accusations that the DOJ is actively covering up the files rather than following the transparency mandate. To understand why this matters, we have to look at what happens when a Justice Department is so focused on high-profile political goals that the system of justice itself begins to break down. There is a concept in law known as the Brady Doctrine, named after a 1963 Supreme Court case called Brady versus Maryland. It holds that it is a violation of a defendant's due process rights if the government fails to provide them with evidence that is favorable to their case. This includes exculpatory evidence that shows innocence or impeachment evidence that calls into question the truthfulness of a witness. Crucially, the Supreme Court has held that this obligation applies irrespective of the good faith or bad faith of the prosecution. The prosecutor is responsible for any evidence known to the entire prosecution team, which includes the police, crime labs, and other agencies. In a healthy system, this requires meticulous work, careful communication, and adequate staffing. But legal scholars have identified a crisis of accidental Brady violations that occur when the justice system is dysfunctional. Many prosecutors are inexperienced, undertrained, and carrying excessive caseloads. In some jurisdictions, felony prosecutors may be handling 1,500 cases per year. When a system is stretched this thin, prosecutors often miss exculpatory evidence simply because they don't have the time to look for it. For example, in a recent murder case in Ohio, the police department held a witness statement for more than a decade that described the shooter as black. The defendant, Michael Buhner, was white. The prosecutor told the court that no exculpatory material was available, and the evidence only came to light years later through a public records request. The court found that while the prosecutor didn't intentionally hide the evidence, it was a clear Brady violation because the police had the report and it wasn't turned over. In another case, a prosecutor in Missouri was so unprepared that they added a witness on the very morning of the trial. The prosecutor told the defense that the witness had a drunk driving conviction, but a later check by the defense showed the witness actually had multiple felony convictions for crimes of honesty, like stealing. The prosecutor admitted they simply hadn't run a background check. These accidental violations are a sign of a system that is failing to perform its basic functions. Scholars note that the criminal justice system is often not a system at all, but a jigsaw puzzle of pieces that do not communicate well. There are no clear protocols for communication between police and prosecutors, leading to delayed or incomplete information transfers. Junior prosecutors often lack the institutional knowledge to even know what evidence to ask for from different law enforcement agencies. Now, consider the current situation at the federal level. You have an attorney general and a DOJ leadership that is under direct pressure to act fast on political prosecutions. You have the disbanding of units like Task Force Klepto Capture, which investigated corporate money laundering and illegal exports. You have the scale back of enforcement for foreign lobbying and bribery laws, and you have a complete reorganization that puts political aides in charge of ethics. When the focus of the DOJ shifts from the steady, careful work of career professionals to the swift justice demanded by a political leader, the risk of these systemic failures increases exponentially. We saw this with the Lindsay Halligan blunder. The rush to prosecute James Comey and Letitia James led to a failure to follow the most basic legal requirements for appointing a prosecutor. The result was not justice, but a humiliating loss for the administration in court. This tension between political loyalty and the rule of law is a theme that has followed Pam Bondi throughout her career. In 2013, while she was the Attorney General of Florida, her office received more than 20 complaints against Trump University and related entities. Students alleged they had been defrauded out of thousands of dollars in real estate seminars that were described by former employees as a scam. At the same time that the New York Attorney General was filing a lawsuit against Trump University, Pam Bondi personally solicited a campaign contribution from Donald Trump. 4 days after her office told a reporter they were reviewing the allegations in the New York lawsuit, Bondi's political committee received a $25,000 contribution from the Trump Foundation. Ultimately, her office decided not to investigate the complaints or join the New York lawsuit. While the Florida Commission on Ethics said the situation may raise suspicions, it did not find that she broke the law. However, the timeline suggested a link between the contribution and her office's decisions, leading ethics groups to request investigations into whether she accepted unlawful compensation for her official behavior. Years later, Bondi served as one of Trump's impeachment defense attorneys and was a vocal supporter of his claims regarding the 2020 election. After she was confirmed as U.S. Attorney General, she continued this pattern of loyalty. She approved Trump's acceptance of a $400 million luxury plane gifted by the Qatari government, a government she had previously represented as a lobbyist. She also put the head of the DEA in charge of the local Washington, D.C. police force, a move described as an unprecedented federal takeover. This takeover was justified as a response to crime, despite the fact that D.C. recorded its lowest violent crime rates in 30 years in 2024. Some observers see this not as a public safety move, but as a test of how far the administration can go in consolidating power. At the same time, the administration's focus on large-scale immigration sweeps has reportedly led to a drop in human trafficking arrests. Child exploitation indictments fell by 28% as Homeland Security agents were redirected toward immigration quotas. The message from these documented events is that the Justice Department is undergoing a wholesale transformation. It is a shift away from a system of checks, balances, and career expertise toward a model of personal enforcement and political retribution. When we talk about justice, we are talking about a process that is supposed to be predictable and fair. It is the idea that if you are accused of a crime, you have a right to see the evidence against you. It is the idea that the prosecutor is an architect of a proceeding that does not comport with standards of justice if they hide that evidence, even if they don't do it on purpose. But in the current DOJ, we see a different set of priorities. We see an administration that views the Oval Office as a throne room and the DOJ as a tool to inflict pain on his enemies. We see a president who boasts, "We took the freedom of speech away," while promoting unconstitutional bans on flag burning. We see a system where justice is defined as acting fast to get revenge. This brings us back to the Brady Doctrine and the accidental violations that occur in a dysfunctional system. When the people at the top of the DOJ are more concerned with political DMs and helping their family members than with the meticulous work of following the law, the entire system begins to decay. Errors like the one in the Comey case become more common. Constitutional rights like the ones protected by Brady are more likely to be violated. The legal scholarship on Brady violations suggests that the solution is more training, lighter caseloads, and more senior career supervision. It recommends the use of checklists to ensure that prosecutors don't forget to ask the police for 911 recordings or witness statements. It calls for a flow of information that is protected from political interference. But the current trend is in the opposite direction. Senior career supervisors are being replaced by political aides. Divisions that prosecute government corruption are being disbanded. Whistleblowers are being fired for pushing back against illegal orders. And the Attorney General herself has been described by some as a personal enforcer rather than a neutral law enforcement officer. As these events continue to unfold, the question for the American public is whether the Justice Department will remain an institution that serves ours or whether it has truly become his. The patterns we have documented, the family interventions, the political pressure for prosecutions, the procedural blunders, and the admitted violations of transparency laws all point to a department in the middle of a profound and troubling identity crisis. The struggle over the Epstein files, the Comey indictments, and the ethics rules within the DOJ is a struggle for the very soul of the American legal system. It is a question of whether we will continue to have a government of laws or whether we are moving toward a government of men and women who believe they are above the law. To help clarify this complex situation, you might think of the Department of Justice as a high-precision machine designed to deliver a single product, impartial justice. For that machine to work, it needs thousands of finely tuned parts, career professionals working in perfect synchronization, following a strict manual of ethics and procedure. When you begin to replace those precision parts with pieces that are only designed to respond to a single remote control, the machine might still run, but it won't deliver justice. It will only deliver whatever the person with the remote control wants, and in the process, the machine itself will eventually break down.